Out on bail, a woman recently sent to prison after being convicted of killing a man in a deadly crash is out after posting bail. The district attorney in Saratoga County says although legal, this is a rare occurrence. Pat Bailey spoke with the DA this afternoon, has got more on the story tonight in studio. Pat?
Jerry, Traci Briskin was sent to prison less than 2 weeks ago after a jury convicted her of manslaughter. Now, she's appealing her case like thousands of others who do behind bars. However, unlike a large majority, she will wait to hear her decision at home instead of a jail cell.
A homemade cross bearing the initials of Thomas Baker sits along the roadside of where he died. His car was hit by Traci Briskin's last November. She had alcohol in her system. After almost a month in intensive care, Thomas Baker died.
The proof showed that Traci Briskin, was driving while ability impaired. She was driving at a high rate of speed. She crossed the center line several times. She crossed the fog line. She said herself that she took her eyes off the road for 30 seconds.
Briskin was convicted of manslaughter by a jury, but just 11 days after being sentenced, she is out of prison, temporarily free again. Much like other inmates, Briskin appealed her case. She asked a judge to let her out of prison on bail while she waits. An appellate court judge agreed to do so if she paid a $75,000 bond, which she did.
Appeals can take years, and so it's certainly, disappointing to us that the person who began her sentence, that the jury had spoken, that the family was now finding some time to have this put behind them, has to kind of reopen the wound again and now deal with this for a year or more in terms of while the appeal pens.
Attorney Paul DerOhannesian says it is not uncommon for someone to be awarded bail while they wait an appeal. Despite a death occurring, manslaughter is not considered, under state law, to be as serious a crime as murder or raping a minor. Two offenses you cannot be granted bail for.
Remember that you don't look at who the victim is, you look at the nature of the crime and the level of the crime.
That's what the law reads.
That's how New York law reads. As long as you can show that there is some decent argument that you have for an appeal, if you have a basis for an appeal, the judge is probably likely to set bail.
But District Attorney Jim Murphy says that is tough to explain to a victim's family.
That's the part for me that is so frustrating as a DA, to have to deal with that emotion again, to try to explain to her why the system doesn't function the way they want it to, with little to no notice. And it's disheartening.
Attorney Paul DerOhannesian tells me that a judge takes many things into consideration before granting bail, including prior criminal history. Now, District Attorney Murphy says while Ms. Briskin sits at home waiting her appeal, his office is still unaware of what her attorney is appealing, whether it's the conviction or the sentence itself. Jerry?
Well, Pat, how long could it take a judge to rule on and return a decision in her appeal?
That's a great question. The one the DA says is also a great question. Now, DA Murphy says it could take up to a year, maybe a year and a half. Attorney Paul DerOhannesian told me today that the appeals process is usually sped up by the defendant's attorney. However, since she's already out of prison on bail, he says there's no incentive here to speed things up.
Interesting. All right. Well, thanks very much, Pat Bailey, for that report.